syllabus, labor laws 1 paper, and we are focusing on unit 4 here, the Employee Compensation Act of 1923. This is our second video for the unit 4. In the first video we discussed about the concept and importance of social security, influence of ILO and constitutional mandate in India. And in this video we are going to discuss about Employee Compensation Act at high level, what is a bird's eye view, and in subsequent videos or in upcoming videos we will be discussing details. Okay, focus area subject area of this particular video is a bird's eye view of an act, what all it covers, what are the key sections in it and other things. Okay, the first one is the act came into force on 1st July 1924. Latest amendment of the act was made in 2017, and this particular law is applicable to all over India. There is no exception to it. The basic objectives of the act are to provide the employee from hardship arising from accidents, to protect the employees from hardship which arises from the accidents, and the second one, provide cheaper and quicker disposal of disputes relating to compensation through special tribunals. So the first one talks about giving some compensation to an employee at the time of accidents, and the second one talks about a quicker resolution of conflicts between employee and employer through a tribunals instead of going through a court civil case. These are the two major objectives behind this act. And on the right side we can see key sections which are important from the examination perspective. Section 2 deals with the major as usual definition of key terms like employee, employer, dependent, partial disablement, total disablement, etc. And section 3 to 7 deals with the compensation calculation of an employee. So for section 3 deals with the employer's liability for compensation, and section 4 deals with the amount of compensation, section 5 deals with methods of calculation of monthly wages, and then section 6 half monthly payments, and section 7 talks about communication of half monthly payments. And finally the section 30 to 36 talks about appeal process and the rules related to social security laws, or rules related to Employee Compensation Act. If we look into Act, there are total 36 sections and broadly divided into 4 chapters. Chapter 1 deals with the preliminary, which are section 1 and 2, and then chapter 2 deals with the compensation related act area, like it starts from section 3 and ends at 18, and chapter 3 talks about appointment of commissioner, and then reasoning of and the entire process of appeal and other things from 19 to 31, and chapter 4 talks about the rules, section 32 to 36. And apart from this 36 section, this particular act has 4 schedules. Schedule 1, list of injuries. It talks about the list of injuries, whether total disablement or a partial disablement. Schedule 2 talks about the list of persons included in the definition of employee. It is a big list. And schedule 3 talks about the list of occupational diseases. Schedule 4 talks about lump sum calculation of compensation. This is a bird's eye view of Employee Compensation Act of 1923. Okay. In the initial slide we saw 2 objectives. Here are the detailed objectives of Employee Compensation Act of 1923. As I said, it is to provide a payment of compensation by employer to an employee in case of injury and accident. So this particular act was developed basically to provide a compensation to employee in the case of injury which happens by accident. Okay, by accident, if any injury happens to employee, then employer has to pay some compensation. How to pay it and what is the compensation limit, etc. is the subject matter of Employee Compensation Act of 1923. And the basic motive beyond these kind of acts are the cost of product should bear the cost related to blood of the employee, because if any product, right, the basic cost of the product should also include the cost related to a blood of the employee. If any employee dies, his cost also should be included in the total cost of the product. And the third important objective is cheaper and quicker disposal of disputes related to a compensation. cheaper and quicker disposal. If there is no Employee Compensation Act and the Commissioner of Employee Compensation and other things, then for any kind of disputes, employee or employer has to go to a court and then fight a case, civil case or criminal case, as the case may be. So in this condition now, as we have a commissioner of employee compensation, then it is easy where employer and employee can go to this tribunal and close their dissatisfactions or any matter related to a compensation, and it will be very quicker compared to civil courts. And it is a humanitarian measure. So basically compensation, whether even if employee is negligent and if death happens, right, in that case employer has to pay compensation because it is on a humanitarian measure. So this act is a something like a humanitarian measure. It is not a remedy for employer's negligence. Please note that, as I said earlier, it is not the remedy for employer's negligence. It is just a humanitarian measure where if there is a loss of a person's life happens, whether it is employer's negligence or a employee's negligence, there should be a compensation to be paid. It is not that the employer has done a mistake and is paying a compensation. This was clearly held in the case of Secretary of State versus Geeta. Here employer is not at mistake, but the accident happened and he has to pay compensation. That's it. So any rash or negligent act on the part of the workman is not a bar to any claim for compensation under the act. As I said earlier, if there is a negligent act from the workman also, he can claim a compensation under this act. This was held in the case of R.B. Mundra and Company versus Banwari. So before passing this particular act, let's look into what are the defenses available to employer to not to pay compensation to an employee. The first defense was doctrine of assumed risk. We all know, right, in law of torts and in the first year we have learned voluntary non-fit injuria, which means if any person joins to an employment knowing that there is some risk in that particular job. Okay, if any person joins as a driver, he knows that there may be a possibility of accident. If any person works in a boilers, there is a possibility that the water may spill over on him, hot water, and he get injured. So the employer used to take a shelter under the doctrine of assumed risk or voluntary non-fit injury. A person has accepted and then joined the job, so he is not, employer is not liable to pay any compensation in case of accident. That is the first defense which employers used to use earlier. And then end of personal action with a death. Okay, if any personal action done by an employee and it resulted into a death, not an official work because of some is personal nature, and I think if he does something and it resulted into a death of an employee. So employer used to claim this as an exception and then get a defense for not paying a compensation, end of personal action with a death. And then the doctrine of common employment. If any person is working on a similar kind of a work with a several manufacturers or several companies, then he could have then employer uses this as a defense. If he is working for several persons for a common purpose, okay, if it is for example a transport company, which is used by company A, company B, company C, okay, if driver dies in an accident, the company A says that they were working for B and C. So it is something like a common employment, and in that case employers used to take some shelter. And then the doctrine of contributory negligence. It is sheer negligence of an employee. Employer has given all the facility for a safety and security in the places, but employee ignores those security and safety aspects and performs some act and results into a death or anything. So employer used to take a shelter under this doctrine and furnish a detail of what are the security and safety actions taken, and then used to get a defense for not paying compensation. So these are the four doctrines which employers used to use earlier, but whenever the death happens, right, it is a loss to a person, and humanitarian ground, some compensation should go to him. So considering all these things, there are few acts which are enacted: Employee Liability Act 1936, Fatal Accident Act of 1855, and then finally Employee Compensation Act of 1923. All these acts, right, these acts present, it defenses the, it reduces the employer's defenses and try to protect the employee's interest, try to protect the employee's interest. That's it in this particular video. Uh, Sorry, the last point is applicability of this act. We know that it acts apply to all of India. It applies to employees in factories, mines, plantation, transport establishments, construction works, railways, ships, circuses, hazardous occupations, and employment is specified in the Schedule 2 of the Act. There is a list of employees which they have given in a Schedule 2. This is applicable to all those persons who are applied in Schedule 2. But this particular Act does not apply to armed forces. Majority of these labor laws will not apply to armed forces. So in the same way, this also will not apply to armed forces. And this covers all the employees in the organization, but not a casual workers. Casual workers who does some small works which are not related to a core of the business, cleaning and other things. So this we will discuss in detail in the other videos. So this act applies to employees but not to a casual workers. Don't misunderstand casual worker with a temporary worker. Casual worker is someone who is working on a small items, miscellaneous items which are not critical, which are not part of the trade or a business of the employer. Okay, and finally the governments have been empowered to apply the act by notification. This particular act applicability and changes and other things, the state government can take a decision on that, and they can issue a notification for the applicability of the act, and that notice must give in 3 months in advance. That's it from an introduction part of Employee Compensation of Act of 1923, and in the next video we will discuss few key terms. Thank you.